Thank you, Your Honor. I'm Jim Carpenter. I'm here on behalf of Mr. Sloan. This case started out by Mr. Sloan issuing a request for public documents, public records under the Freedom of Information Act, and he was turned down. He received a letter back saying that the Friends of the Hunley was not subject to the Freedom of Information Act, and they would not provide the records. Mr. Sloan filed suit alleging a violation of the Freedom of Information Act, asking for declaratory judgment and injunctive relief, and then shortly thereafter, the Friends of the Hunley provided the documents that, or most of the documents that were requested, and maintained, though, that they were still not subject to the Freedom of Information Act. As this case has progressed, and there have been many letters in which the Friends of the Hunley has said, we are not subject to the Freedom of Information Act. The record contains 9 such letters. 6 of them were to Mr. Sloan, 3 of them were to someone else. And as the court mentioned 2 days before the hearing, they now tell this court an invitation, more or less, to rule against them on the application of the Freedom of Information Act. And one question the court may have is this necessary? And the answer is yes.
You take that letter to me, and of course I'll ask Mr. Sowell this, that they now admit that they are a public body as defined by the Freedom of Information Act? Or do you take it to mean something less than that?
Something less than that.
Okay.
I think that this is, and I think it's necessary for this court to rule on this because of the 9 letters in the record in which they say we're not subject to the Freedom of Information Act, and now they're saying, well, it just doesn't matter to us anymore. But I think it's an important public issue, and I think that's why the court, one reason the court took this case up, the application of the Freedom of Information Act to a corporation formed by a governmental body. The corporation here received and expended millions of dollars of taxpayer funds, and I'm informed that a year ago the Attorney General in a letter, informal letter, said, yes, of course Friends of the Hunley is subject to the Freedom of Information Act, but that was a year ago. Now, and we do ask the court to find that Friends of the Hunley is a public body under the Freedom of Information Act, number 1, and number 2, that when they said, no, we're not going to provide the documents to you, that was a violation of the Freedom of Information Act. And I think under the statute, we're entitled to ask for that. Under the statute, requesting parties can request declaratory judgment and injunctive relief. The fact that they produced the documents to us makes moot our request for injunctive relief, but it does not make moot our request for declaratory judgment that Friends is a public body under the meaning of the Freedom of Information Act. And it doesn't.
You have to have some reason to ask for that declaration. And that reason has evaporated now that they have given you all the documents you want by the admission of Mr. Sloan, the plaintiff in this matter. He says in his testimony it's purely an academic exercise now. The FOIA request has been honored, and they now stipulate that they're covered by FOIA. So why would we even have the authority to make a declaratory judgment about the status of the corporation itself in light of the fact that it's kind of doubly moot?
Well, I think that I would disagree slightly with the court's characterization of what their letter says. Their letter says we're not going to fight it anymore, and I read that to be it's just not that important to us. So go ahead and rule against us on the question.
They asserted that we're not going to fight it in this case.
Right.
Is that what their letter means?
Should the issue be reached and considered by the court, the Friends of the Hunley will not contest the assertion.
Let's say we've never gotten this letter from the Friends. We've got testimony from your client saying, I got everything I requested, and therefore my interest is only academic. We don't issue declarations on academic matters, do we?
No, this court decides cases, and this is a case of public importance, I think.
What's the public importance in light of the fact that the Freedom of Information Act has been complied with?
Well, it has and it hasn't. There's another man, Mr. Stender, who made several requests under the Freedom of Information Act.
He's not before this court at this time.
That's true, but they told him no, and they didn't give him the documents, and they didn't give us the documents until after we sued him. So then should the court allow an entity to say, no, we're not going to comply with the Freedom of Information Act until you sue us, and there'll be a lot of people who can't afford to sue them. Even though there is an attorney fees provision, it's not in keeping with the public policy of this state to allow an entity to say, we're not going to give you the documents, but then when you sue us, well, okay, we'll give them to you, and for 4 years maintain we are not subject to the Freedom of Information Act, and on the eve of Supreme Court arguments say, well, it just doesn't matter to us anymore, so that takes it out of the hands of this court. I just can't believe this court is that powerless to issue a public importance decision on this point of whether Friends is subject to the Freedom of Information Act. And also, the statute says that we don't have to keep going back to them to ask and say, please, pretty please, will you give them to us? We ask once, and they give a response, and the statute says that first response is a final response. And they gave us a final response that says, no, we're not giving them to you, and we're not subject to the Freedom of Information Act, and that issue has never been ruled on by any court as far as I can tell. And that's what cries out for a ruling, I think, from this court. Was it a violation when they said no, ma'am?
What difference would it make, Mr. Carpenter? We don't have any requests up here about attorney's fees or anything like that. All the documents that have been requested have been given. So if we made an opining that the Friends of the Hunley is subject to the FOIA Act, what difference would that make?
Well, I think, number one, it'd have to be remanded for a calculation of attorney's fees, because the statute presumes an award of attorney's fees on enforcement of FOIA. And I think it'd have to be remanded for a factual finding about what attorney fees are appropriate. But Mr. Sloan has spent 4 years and many, many tens of thousands of dollars fighting this case, trying to get a judgment that says that the Freedom of Information Act does apply to the Friends of the Hunley. And when they said no the first time, then that was a violation of the Freedom of Information Act. We had a second cause of action that is termed an alter ego or an agency cause of action. And under that one, we're saying that when a government entity forms a corporation, they cannot expand their powers by the formation of that corporation, nor can they limit the restrictions of the government entity by acting through a corporation. In this case, the Friends of the Hunley maintain, and it's on page 39 of their brief, the powers enjoyed by Friends are in keeping with powers generally bestowed on nonprofit corporations in South Carolina. They maintain that Friends of the Hunley, and that's in the footnote on page 39, they maintain that Friends of the Hunley is a corporation, and the corporation can do and is not limited by things that limit the Hunley Commission. And these kind of corporations are popping up all over South Carolina. Government entities all over the state are forming corporations and trying to act through corporations to do what government entities are not permitted to do under the statutes by which they were formed. And that, I think, is another important public interest matter that this court needs to address. Can a government entity form a corporation and do, through a charitable corporation, something it couldn't do otherwise? Spend taxpayer money in a certain way, evade the strictures of FOIA.
What possible authority do we have to get into all of that without any kind of live case of controversy? It's not like we got fusses about expenditures on Ms. Anwar's dot or anything like that pending. We've had cases up here before, like the Weston case that dealt with the educational foundation of a university and so forth, but they always involve a case of controversy about expenditures. What is it you're asking us to do when we make this ruling that the Friends of the Hunley Incorporated is the alter ego of the Commission?
Right.
Are you saying that the Friends is the alter ego of the Commission, or that the Commission is the alter ego of the Friends? Or?
Yes. The Friends is the Commission. The Friends is the alter ego of the Commission. So the Friends is not permitted to do anything. The Hunley Commission was set up by statutes, and any time a government organization is set up by statute...
So no private foundation that's ever established that has as its mission supporting a state entity can do anything that the state entity can't do? Is that what we're
that's not exactly it, no. Ordinarily, a charitable corporation is set up either by another corporation, which is free to do anything that's legal under the law, or it's set up by persons who are free to do anything that they're allowed to under the law. But a government entity is not like a private corporation. A government entity is limited in how it spends its money, the things that the statute allow it to do, the purpose for which it was set up. And when a government entity forms a corporation, it still must live within those parameters of the authorizing statute.
Your contention is that despite the incorporation documents that would say otherwise, that the Friends of the Hunley was really secretly formed by the Hunley Commission?
The Hunley Commission admits that, Your Honor. Mr. McConnell.
The Hunley Commission is not even a party in these proceedings.
Mr. McConnell, and I see my time's up, if I could finish the question.
That's all right. We're going to try to get to the bottom of this. The state of South Carolina's commission, the Hunley Commission, is not even a party here. So how can they admit anything?
Well, one of the things that opposing counsel relied on was an Attorney General opinion that was issued about a year ago.
The Attorney General's a long step from the Hunley Commission, though, isn't it?
I'm getting there.
All right.
Mr. McConnell, who was the chairman of the Hunley Commission, wrote to the Attorney General and said, our Hunley Commission formed a corporation. And it is the Friends of the Hunley. And is this okay? And the Attorney General a year ago wrote back and said, we think it's okay for you to form a corporation. This was October 22 of 2004. And the Attorney General quoted the letters. And this is an opinion they rely on in their brief. It's published in Westlaw, and it's a public opinion. But we have maintained,
it has
they have
zero weight up here for any purpose whatsoever.
All right. They do not dispute the fact, I don't believe, that the Friends of the Hunley was formed by the Hunley Commission. There's evidence in the record that the incorporators were the chairman of the Hunley Commission and the vice chairman. It was a government check that paid the filing fee. It was the legal counsel of the Hunley Commission that drew up the papers. They used the post office box of the Hunley Commission. They used the physical address of the Hunley Commission. All the money that the Friends of the Hunley gets from the federal government flows through the Hunley Commission to the Friends of the Hunley. All that evidence is in the record that
But what kind of controversy have we got up here that make any difference to us and anything that we would decide up here in this case?
All right, Friends of the Hunley has exceeded the powers of the Hunley Commission, we think, and we think that this court can issue declaratory judgment that says that any action they take is limited by the limitations on the Hunley Commission. And I think they have started doing preservation and conservation of things other than the Hunley. The Hunley Commission was set up for the raising and preservation of the Hunley submarine. And now they've done a project that relates to artifacts from the Normandy invasion, which is, meaning the World War II Normandy invasion, which is a far cry from the preservation of the Hunley. And
none of this that you're reciting to me now is in this record or in these pleadings whatsoever, is it?
I believe it's in depositions that we took in this case.
Well, I can only go on the basis of what's in the record I'm looking at. I mean, it's okay to play to the cameras if you want to and make these kinds of arguments, Mr. Carpenter, but this court's not the platform for that. We don't have any case of controversy up here in which whatever these Friends and the Hunley Commission are doing makes any difference to our ruling about the Freedom of Information Act.
Right. The case of controversy, I think, would be indicated by that footnote 15 where they said that the corporation has all the powers generally bestowed on nonprofit corporations in South Carolina. And I contend that if it's a nonprofit corporation formed by a government entity, it can have only the powers of the government entity.
I understand your contentions, okay, and they may be very valid ones, but what is the platform by which we can make any ruling about such things?
Well, this case came up on summary judgment. It was not tried below, and I think that what we would ask for is a reversal of that summary judgment that threw that out, and we could develop the facts in the court below. Now, the first cause of action, the Freedom of Information Act, I think all the facts are here, and certainly the court can make a ruling on that. The second cause of action, not having been tried below, I think should be remanded for a development of the facts and presentation and fact-finding in the trial court. But the theory, I think, is valid, and I think that the presentation of facts would be developed in a remand.
I understand. Mr. Sam?
May it please the court.
They really mad you waited until now to make all